SKYROCK, your quantum solutions.
Hi, everyone. Welcome to Thought Stream on SKYCIETY, brought to you by SKYROCK Galactic with your hosts, myself, Ashley Dite, and Kingzilla. Today, we are venturing into the realms of courage, wisdom, and the art of self-representation. In today's world, the scales of justice are tilted, and courtroom battles are daunting. It takes more than just bravery to stand up for yourself. It requires knowledge. That's why we're not just discussing the concept of being brave, we're giving you the tools to embody it. Today, we are incredibly honored to welcome Richard Mendez, a remarkable individual who has not only trained with the legendary Bruce Lee, but has also mastered the art of navigating life's battles with grace and strength. This journey is a testament to the power of perseverance, discipline, and the indomitable spirit of the human will. We are here to empower and educate and shine a spotlight on the incredible resource that's a game changer for anyone stepping into the legal arena, the David versus Goliath app. This is a how-to legal revolutionary platform that's designed to demystify the legal process, making it accessible for litigants to represent themselves competently and confidently in court. Richard, welcome to SKYCIETY on ThoughtStream. We're welcome to have you, and we're so happy that you're here. Can you explain more about what David and Goliath is?
Yes, I can. That was a wonderful, beautiful opening. I hope I can follow that. I mean, it's really marvelous the way what you expressed. Yes, my name is Richard Mendez. I got involved in this back in about maybe 15, 16 years ago by accident. And we decided to develop David versus Goliath because a lot of us as pro se litigants, me included, did not know anything about the legal system. We didn't know how to go into court. We always relied, and we were told to rely on attorneys when we go to courtroom. And a lot of times, an attorney is just like a mechanic. You can't take a mechanic that works on Volkswagen and have him work on Lamborghinis. There's two different concepts there, two different vehicles, and so here, what I found out is that not every attorney understands the system. And especially what I'm going through with David's Goliath is to help people with foreclosure issues. But even though it was foreclosure issues, we found out that once you really understood the courtroom procedures, it went across the board. It didn't make whether criminal, family, traffic, or a foreclosure issue or civil issue. So David versus Goliath was, we started to group our people together to help understand when you walk into a court, who has the power. And we began to find out that the people have the power, but they didn't understand that because we weren't taught to read and research. They took this out of the system, so we didn't know that. So by accident, I started getting involved and I started looking at courtroom procedures. I started looking at evidence codes. I started looking at civil codes. I started looking at the judicial canons for the judges. And I started questioning, who is a judge? What can he do? What can he not do? And we have everything there. Everything's there. It tells them exactly what they have to do. You read the judicial canons, they tell them what they can do and how they're supposed to proceed. They can't act any indifferent. They can't raise their voice. They can't make their decisions based on emotions, which happens a lot of the times when they get upset with people. And then we found out that there was objection codes, evidence codes, things like this that we could object. So once we began to understand these things, we started applying it to people, and they become more successful. Not only becoming successful, they become more confident going into courtroom. Okay. That's how we started David versus Goliath.
That's really cool. That's really cool. Now we're bringing that together and even working on AIs for each and every state so that they can be educated and people can go on and use those tools. But of course, they still have to learn themselves. You can't rely on the AI to do it all for you. There were some really cool things that you talked about, like taking a field trip to court. and watching how that goes down. That's a great, great tool that all of our listeners and viewers can take in right now and think about, especially if you are going through court battles or one of your loved one is. And boy, oh boy, we know that that's affecting so many people out there, and it affects their health. It hurts them. They start to have pain, depression, anxiety, all of these things. But once you go in and you start to equip yourself with knowledge, all of those fears pass away.
Absolutely. One of the things is it's just like any other game you get involved with. When you first start out, you really don't know the rules. But as you begin to study the rules, then you don't lose as much. You begin to become more successful at it. And so one of the things I tell people is this is since they don't understand about the court system, I always tell them the most important element of walking in a courtroom in your own procedure is that you have to have a court reporter. A court reporter is the most important element of your case, because what happens is without having a legal transcript of what's being said, challenged, objected, requested to be admitted as evidence, what's stated in there falls on deaf ears, because there's nothing you have nothing to be able to take it to the appellate courts. And they've routinely told us that we cannot rule when the court is silent. See, and this is one of the things that people didn't understand. They would argue, and the judges say this, they know this. The judges would say, well, if you don't like my opinion, appeal it. But they know that you're going to lose because there's no court reporter. And there's so many little strategic things that you have to learn. And that's why we started David versus Goliath, because there is a lot to learn. And it's simple, but we've broken it down to the easiest, so it doesn't take as long. You don't have to spend like 5 years or 2 years of going to study a law. You can learn this stuff within 6 months to 8 months if you really apply yourself to this. Okay.
Definitely. Kingzilla, I'd love to hear what you're thinking and your take on this.
Well, first of all, I love the name, David versus Goliath. I think that's a very powerful name because it makes me think about how the little guy David in the Bible went up against the giant, and the odds was really stacked up against him to win. But he won the battle, and it was a great victory. I like to just point out, like, for a lot of people, and you spoke about this, the fear for a lot of people is a real issue. Just the simple fact that they may have to go to court can put a certain dark cloud over people's heads and really create a certain type of feeling and vibe within themselves before they even enter the courtroom. So what would be some of your suggestions in helping people overcome that? Because when you're speaking before a judge, jury, all that type of thing, there's a lot of stuff that's going through people's heads, their emotions. And I know you educate people on the laws that are there for them to use, but what would be your suggestion in helping people with the emotional part of it and the fear going into that courtroom?
Now, that's a good question, because that's one of the things that we run into all the time. I had a lady come to me, just to let you know, that she sat here with me for about 3 weeks, and she had a court case, and I said, okay, let's walk through it. I'm going to start talking. I'm going to have you say certain things, and I'm going to press it. And as soon as she gets so nervous, she said, I got to go to the restroom. And then she come back. And I said, we're not even in court. We're just sitting here talking. And that's what people do. They get anxiety, they get nervous. They feel like they got to have a bowel movement right away, or their stomach gets upset. And so what we did is we started doing mock courtroom procedures, where we walk through the process. What we do is we write out a scenario and we give that information to them. And then they read it over and over, and they study it over and over quite a few times. And then they start regurgitating it. And what they do is we walk them through back and forth. And then we don't see it. It would be just like training a fighter. What you do is you train him outside the ring on how to use his tools, how to slip, how to punch, how to react, and things like that, before you put him inside the ring to get punched. See, and you go over and over and over and over. The more you go over it, the more comfortable you get. Then you put him in the ring, and you don't put him with the greatest fighter. You put him with somebody that'll work with him, that works with him punching. Well, the same thing here. We do the same thing, because you don't want somebody just, you don't throw them in the ring and somebody just that's really good just blast the heck out of you. There's no way that you can succeed. So we do the same thing here. What we do is we take a scenario, then we do is we'll type up the information. We'll say, what a lot of people do is we have them say, "Good morning, Your Honor. My name is so and so," and they'll say, "Good morning, Your Honor." And you'll say, "Your Honor, is this matter being recorded today?" And I'll say, "Yes, it is." I say, "Okay, Your Honor, can I use that for reversible error on appeal if I need to?" The court will say, "Well, yeah." See, psychologically, we letting the judge know that we know something, but he doesn't know what we know. When we say reversible error, that means, oh, he better be on his best behavior, because if he's going to mess up, we're going to ask to have it reversed in appeal, and he don't want to have that done. So basically, we talk like that, and then what we do is we say, "Okay, Your Honor," he'll say, "All right, we're going to swear in," and then we swear to tell the truth, the whole truth, and nothing but truth. But I'll tell you, no attorney ever swears in. They never ever swear in, and they're required to testify, and they do this all the time. So what we do is we walk through these scenarios, and people that have a case coming up, we will design a dialogue for them, and then put it together, then work with them, because we know that when you get in court, things can change up a little bit. So once they get the dialogue down, then that's when we say objections, and we start interfering with their dialogue a little bit to give them the comfortability to be able to learn how to respond. So we work with them just like a trained fighter does, to help them to find the comfortability zone for them before they go into court.
That's
That's
really
good.
helpful.
Yeah, that sounds like a really good thing, because yeah, a lot of people do experience that. So yeah, I like your explanation for that. Yeah, that's really cool, especially from the fighter point of view. A lot of people be able to relate to that.
And what's really amazing to me is, and I can relate to that, because I was fighting this. I remember when I started training, and we were doing, because we used to wear boxing head gloves and mouthpiece and stuff, because that's the way that Bruce fought. We hit. And so when I first got there was a guy who's better than me, and this guy was beating the heck out of him. And my teacher, he said, he stopped the sparring matches, because we had several of us going on. He said, "Okay, switch." So he put me with a little 16-year-old kid, and he said, "Rich, I want you to keep him honest with the jab, but he said, I want you to work on your slipping, countering. I want you to slip inside, slip outside, counter and hitting." And I was so mad, because I was angry. I still wanted to fight this other guy, but he put me with this guy. But as I was going with this kid, I think, hey, what I couldn't do there, I can do here, because I wasn't ready to go there. But he saw that I needed to train better here, so he put me there. So that's which I've applied to what we're doing with David versus Goliath. We're taking people that are in different levels and have different ways of approaching, and then we have two different meetings. We have one on Monday and one on Wednesday. I always call it Monday. I called it. It was a night. Wednesday night was a night where everybody comes together and they talk about how their feelings were, and what was going on with them, how it affected them. And so I called it Crybaby Night. We just started teasing, but we have people come inside there and we start talking like that. We just, what's going on with you? How are you feeling? And then we discuss that, to be able to help people find a way, to overcome that. Okay. And we have other ways. We have ADAs, advocates that can work with you, that can go into court with you because you feel nervous about them. We have the attorneys that can go in there with you and do that. But I also tell them, you need to understand this stuff, so that if your attorney doesn't raise an objection or says something, then you say, "Your Honor, may I have a moment with my attorney? Because I need to talk to him, because I believe he should have objected at this issue, and I'd like to discuss that." And then the court can let you go off for a few minutes and talk with him, and he can come back and say, "Well, my client wants me to object, felt that I should object on this issue, and so therefore we're going to object on that issue." And then we give our foundation. There's terminology you're going to learn a lot in here that we need to use when we're inside court.
Now, can I ask you another question? Because this is a concern of mine with seeing how the economy across the United States is going on. What is the percentage that you see in the uprise of foreclosures, the difficulties people are having in keeping their homes across the lands now?
That is a really good question, because when I got involved in this at the first time, I was like many other people. I didn't have anything. I was enjoying my Sundays. But then when I got into court the first time and the judge didn't come out to see me, I was really upset. I said, "Why wouldn't he come out? Why didn't he do this?" And the attorney just he knew the courts and he knew the judges. So he just wrote on a piece of paper after he looked at my work, and they handed it to the bailiff. They took it back. The judge didn't come. He said, no, your motion's denied. And I was really upset. I said, no, that can't happen. Why? So it caused me to go in so deep. I started research. I spent 6 years really going as deep as you can go into this stuff to understand how foreclosures happen, why they do foreclosures, how when you enter into to purchase in a home, the American dream, what they did is they failed to disclose, material facts to you that this was going to be converted to a mortgage-backed security, and that they were going to change the meaning, and the interpretation and the meaning of your note. So the note was a promise to pay. What they did is they converted to a mortgage-backed security, transferred to a trust in New York, and what it was bonded and wrapped by a bunch of PIMCO, which is the largest bonding company. They aggregate maybe 2,000, 3,000 notes together, could maybe $1 million, billion, $2 billion. So they aggregate it together, and what they do is they fractionalize it and sell that out to all these. They sell it to all the pension companies, like the judge's pension fund, the police's pension fund, the fire department's pension fund, the county pension fund, and other individual companies, their pension fund. Well, I found out that a lot of that was not on the up and up again. It's an illusion again. And so if it's transferred to a trust, then that means that trust holds it inside that pool for 30 years. When it holds it in that pool for 30 years, what happens? It cannot be penetrated. That trust cannot be penetrated because of IRS tax law and New York trust law, under New York trust law. That means that your notes underneath there have been wrapped in by this bond, meaning that, like, you could take a layer of maybe, let's say, 20 different pieces of cake, and then you put icing around. If you didn't know, and we put your initials on the slice that you had, or the piece you put in there, and you didn't see it, and we put it inside, that you wouldn't be able to tell us where your note's at. See, you couldn't tell us at the middle, at the top, or at the bottom. So when they wrap these things, you don't know where your note's at. But what they do is they fracture. They take a slice, go down, they sell that to the pension fund of the judges. They sell another slice. So a piece of yours has been sold to all these different pieces. So it's a big illusion. So now what happens is, what I found out is, it's not really the banking industry that's foreclosing. It's Wall Street. It's Wall Street, and it's all these other law firms and trustee companies that are fabricating these documents to make it appear as if they're the holders of the beneficial interest, and then they begin the foreclosure when they really didn't have the right to do that. What we do is, in every state, during that time of Obama in 2000, I think it was 2009, he made the Protect the Tenant Foreclosure Act. And when he made the Protect the Foreclosure Act, what they did was, in every state, they made like a Homeowner Bill of Rights Act to protect the homeowners. And every state, you have to look that up. And when you look that up, it's got a statutory scheme that's required by every foreclosure entity. They have to follow that statutory scheme. They don't follow that statutory scheme, they don't get their remedy. And I can tell you, 99.9% of them do not follow that. They do. It's all an illusion by these attorneys to be able to do that. So we're trying to help educate these people to be able to show them that the foreclosure industry isn't what it looks like it's supposed to be. So what we're doing is we're educating the people to be able to show them, and then we're looking at the documents to make sure that they're in compliance with the statutory schemes that they created. And if they're not in compliance, then we take them to task on that. And we're being successful at that right now at this point.
Wow, that's really good information, because you know this, that during, I would say, from 2005 going up to 2009, there was a bad situation with a lot of the adjustable arm loans that was sold to people to get into a dream house that technically, under a 30-year fix, they couldn't have afforded the house in the first place. So they came up with what I refer to as trick bag loans, which really hurt a lot of Americans. And therefore, we had a really big crash by 2010 that there were so many homes on the market here in Las Vegas, foreclosure homes, that when things started getting better, they only released so many of them at a time for people to buy, because there was better deals buying the foreclosure homes than getting a new home.
All of that was designed by them for you to fail. So because what they did is they created what they call credit default swap insurance, meaning that they're betting on you defaulting. See, because if you defaulted per se, then that means that they can collect that insurance. That's why they were asking people, if you want to go on a loan modification, you need to be 3 months behind on your loan. Once you're 3 months behind on your loan, then that kicked in the credit default swap insurance. They collected the money on your property, all of it, up to 80%. And so now they got that money, but they don't want to keep paying the certificate holders every month the dividends that they're supposed to be paying. So what they decide, well, no, let's just foreclose on them. We'll keep that money and foreclose on them, you know, at the same time. So that's one of the reasons why they designed in the beginning to do that, where, you know, they had these balloon payments that they were going to go through. They didn't do fixed term, you know, fixed loan agreements, because they knew that you wouldn't build, because over a certain amount of time, your loan would begin to increase, and it would increase so much you wouldn't be able to make the payments on it, you know. And once you enter into a contract, that's one of the things that I began to understand. See, it's all about contract. See, because the contract is the deed of trust or the warranty deed or whatever. These are contracts. Those are specific. So a lot of times what I would find out with people is I would talk with them and I said, well, did you get a loan? Now you're going to get a lot of these people that are out there, like the patrons and other people that say, no, I never got a loan. And I'm going to say yes and no. 50% yes and 50% no. And they said, what do you mean? I said, well, you have to read your contract. The deed of trust says, on the deed of trust here in the state of California, it says loan means debt, comma, evidenced by a note. Loan means debt, comma, evidenced by a note. And you have to look up really what a comma means. You have to look up all this stuff because they designed this. So if loan means debt, then that's what you mean. A loan is what you got. You got a debt. So now we have to stop and look at the promissory note. It says, in return for a loan I have received, I promise to pay. So you've changed the word loan, in return for a debt I have received, I promise to pay. So people didn't understand that. So yet you can say, well, you know, when people got to that, I said, if they ask you a question, what did the judge ask you? Well, did you receive a loan? And they're going to say, no, I didn't. And other people are going to say, yes, I did. I said, well, people didn't really understand their contract. I said, well, Your Honor, I said, if they asked me that, I said, well, Your Honor, I said, that's kind of a tricky question. Can you please define loan for me? So now you have to get his interpretation. Now, if he says, well, loan means when you receive money for something, and then you have to pay it back. Oh, so I'm going to have to object to you making a disposition in this case. I said, because that's outside the boundaries of my contract, because that's not what my contract says. It never says I received money. It says I received a debt. Okay. So that's one of the things that's being able to understand. And it's been able to ask the court's question. A lot of times what we want to do is we get so educated, we want to tell the court that we know the law. We want to tell them all this stuff. What we do is we ask questions. When we get inside the courtroom, when you ask a question, because if you object to somebody testifying in the courtroom and the court says overruled, when he says overruled, that means he's going to allow that. He's overruled your objection, okay? Even though you've objected to that person, because the statute's very clear. It's not vague and ambiguous. The statute under 702 here in California, California Evidence Code 702, says upon the objection of a party, that testimony is inadmissible unless he has first-hand personal knowledge. So therefore, a lot of people would argue, and I said, well, yeah, that raises another strong objection. Is the court stating for the record that you're going to allow hearsay testimony from this person who I objected to make your determination in this courtroom today? Because you cannot make a determination on hearsay. It can only be on facts. Is the judge the trier of facts or the trier of the case? He cannot be the trier of the case. He can only be the trier of the facts. That's what his position is. Say, it's really, you know, it's really simple when you really begin to break this down. And I really spent a lot of times, and let me tell you, I've laid face down on the cement, prayed to God, asked him, because I didn't have any problems. I just didn't like the fact that we have these Goliath beating all the Davids. It's appalling. So what I did was I went and laid on the ground and asked him, please, Lord, help me. Give me the guidance, give me the knowledge, help me to see the things I don't see, understand the things I don't understand, you know, and to recognize the things I need to recognize. And so that's what happened. And so basically what I did was I started reading more, and a lot of things started being revealed to me. And I started thinking, my goodness, this is incredible. We have all the power. Can a judge testify? No, he can't. But they do this. Can a judge practice law from the bench? No, he can't. He can if you don't object each time. You know, can he ask discovery questions? No, he can't. He can if you don't object. And so I decided, well, let me test this. I was in court one time, and a judge started asking me a question about something. And I said, objection, are you asking a discovery question for the plaintiff? Oh, no. He says, I'm just trying to find out about the case. I said, well, isn't that what he's paid for? You know, a counsel? You know, but then I objected him, so he couldn't talk. He can only make statements of what he knew, but he cannot testify. See, all courts, every court is operating on rebuttable presumption. Every court. And if we don't rebut the presumption, the court accepts that we're there and he has all the elements to move forward. But I can prove you that he doesn't every single time. So that's what we did. That's why David versus Goliath came together, is to help the people, help the underdogs, to help educate the people, the moms, the pops, the women, the gardeners, the home makers, mothers, that, you know, they get involved with it, that, you know, we're going to these courts and they're slaughtering us, you know, and you have to find out that, I found out like this, okay, who's your adversary? Is it the judge and your plaintiff on this side that brought the case against you? No, that's not. That'd be just like going in a fight like Mike Tyson, and you're beating Mike Tyson up, you're whopping him, and all of a sudden somebody starts hitting you from behind. You turn around, it's the referee. He can't do that.
Right,
See?
right.
Yeah,
right.
It's the same thing as a judge. The judge can't jump in and start beating you up for the other side. That's not his position. But we don't call him to task on. We didn't know that. And so when you didn't know that, it's amazing how much we don't know. We just rely on this stuff. So that's why, again, I talked to Jackie. I talked to many other people, but they never came together. But I talked to Jackie. I said, Jackie, this is what's going on. This is what you need to do. She said, Rich, let's do it. So within 2 weeks, she had everything up and running. Everything. She went and got the logos, got the foundation, put it up, counts, all that stuff, you know. And so that's where we're at today. And I'm glad that we're here now with you guys, because I think that I want to reach out in a broader scope right now, which we were going to do with David Goliath, but a lot of people don't want me to do like that because they said, Richard, let's keep it closed like this, you know. And I said, well, no, we need to teach more people. People need to each one teach one, you know.
Exactly.
So we become successful. That's our reward. Isn't that your reward? Seeing people being successful?
Amen.
Yeah.
Amen.
Amen.
Now, we definitely have a lot more coming for all of you viewers. And those of you who are going through this, just know we're here. We're here for you. If you want to get involved, you want to participate, find us at SKYCIETY.space. We're happy to provide all of the questions that you would like to have answered. You can check us out on Facebook. You can check us out on Instagram. You can find us on YouTube, and get ready, because there's a lot more coming, but you also have to be ready to learn. You have to be ready to learn. And then that way the fear is removed, and you can be David versus Goliath, and you will win. So stay tuned. We'll be back soon. Check us out. We really appreciate you guys. Blessings.
Blessings. Blessings to everybody. Thank you.
See, I can teach you how to walk untouchable. I can teach you how to talk in scripture all alone. I can teach you what it means to live eternally. Only if you let me.